There are a couple of points that I said I'd think about.
Yes.
If I can come back to you about that. First of all, the issue of illegality. Now, the question before the judge was whether the conduct was unlawful under Dutch law. He had the benefit of expert evidence. The experts agreed that there was no question of breach of the Dutch criminal code. There was a difference of opinion as to whether there might be some sort of civil liability based on GDPR and/or Article 8 of the Human Rights Convention. So the position under English law wasn't relevant before the court. However, for what it's worth, having thought about it over the shorter adjournment, we don't accept that the Fraud Act would have been engaged if that conduct had taken place here. But it, as I said, it's not relevant. The second thing I want to come back about is that Lord Justice Phillips made the point early on in the course of this appeal, that asking whether, or suggesting that the proper course might be to remit the summary judgment application to a trial, because at that stage questions of equitable relief would be considered. The point I should have made, would like to make now, is that the summary judgment application only sought relief for breach of contract and deceit, with damages to be assessed. It did not seek any equitable relief at all. And just to make good that point briefly, can you turn up, please, the supplemental bundle, tab 12, on page 191. Where the last paragraph of that page, the claimants applied for summary judgment in accordance with Part 24. In summary, A, the claimants believe that the first and fourth defendants have no real prospects of succeeding in their defence of the claimants' claims for 1, deceit, and/or 2, breach of contract, and B, the claimants know of no reason why the disposal of the claimants' claims against the first and fourth defendants for 1, deceit, and/or breach of contract should await trial. So the summary judgment application was a very limited application. It didn't raise any questions of equitable relief. And for that reason, I would say that if you were with me on any of our main grounds of appeal, it's a perfectly proper course to remit that application to the information review hearing. Because if it's right to say that there was no defence to a claim for breach of contract, or there's no defence to a claim for deceit for damages to be assessed, one's entitled to ask rhetorically, why on earth does this claim need to go to trial? So that's the second point I wanted to raise. The third point is I may have overstated my position when I was being asked questions by Lord Justice Mayles as to whether or not I accepted that the approach was an abuse. And the answer to that is our position is you can only decide on that once you know the full circumstances, and the full circumstances will include understanding whether or not the material obtained was privileged or not. And the same, of course, applies to the question of sanction. So I think Lord Justice Mayles came back to it again later. We don't accept that the abuse is sufficiently or satisfactorily proved at this stage. It's not a tick box exercise. You don't say just because you can say there's some impact, there is therefore an abuse. You have to consider all the circumstances. So that's the third point I wanted to deal with. Fourthly, before I get to the...
So your position then would be you only decide when you know the full circumstances, including, and you said, one, whether the info obtained was privileged, but I think two, which you also said this morning, what impact on the proceeding.
Exactly. Thank you. Lord Justice Foxton asked me earlier whether or not we were asked whether we were happy with a deputy judge. The application was originally listed for the 4th to 6th of November. At 4:35 on the 29th of October, we were asked whether we would be willing to sit on the 3rd to 5th of November with a hard stop at midday. No mention was made of a deputy judge. We said yes, having rearranged with the transcribers. We were then told 2 days before the hearing that a deputy was going to be hearing the matter. Finally, the Black Cube letter. Now, we've got the unredacted copy, but there is an issue that has arisen that I've asked my learned friend to think about, and he wants to think about it overnight. Just so you know what the issue is, there's no question about unredacting the commercial terms. There is one paragraph that causes us some concern, because that refers to Black Cube, the advice that Black Cube had received, which might be subject to privilege. And we've asked my learned friend to consider whether we can redact that paragraph. And we're going to write to him. He's going to tell us his views tomorrow morning.
Right. Okay. Well, we'll leave it till tomorrow morning. Then.
Thank you.
See what we get.
So that just leaves two further grounds, the second of which will only take about 2 minutes. First ground is procedural unfairness. The judge has accepted that the procedural course he adopted, namely decided to strike out or refuse a summary judgment application while deferring the critical issues of iniquity, confidentiality, privilege and trial fairness to a subsequent information review hearing, wasn't raised with the parties during the hearing itself. That's paragraph 10.7 of the consequentials judgment, which you find at Core Bundle tab 9, page 140, though we don't need to turn it up. The point was also not raised prior to the hearing. We learned of the judge's decision to split the issues and the hearing in this way when we received the draft judgment. There are a number of reasons why we say this decision was wrong and procedurally unfair, which we explain in the skeleton, and I don't think I need to repeat them here. What I propose to do now is merely encapsulate the nub of what we say has gone wrong here. In short, what we say has gone wrong is that the judge didn't give us an opportunity to make submissions on the procedural course of action he adopted without notice of the parties, which is intimately related to what we say is the judge's flawed substantive analysis. If the judge was going to take the highly unusual, and we would say unprincipled and contrary to authority step of deciding on sanction, while excluding from consideration all questions of impact of the conduct in question on the proceedings, he should have raised that possibility with the parties. And by failing to do so, he breached the cardinal principle of procedural fairness. And finally, ground 11, that's another ground that doesn't require much or any elaboration. We said the correct approach that he should have adopted was to adjourn the summary judgment application to the information review hearing. That would have avoided all of the obvious problems that arise from splitting the issues in the way that the judge did without inviting submissions from the parties. By not taking that approach the judge erred, and in this context we rely on all our grounds of appeal. And what we say about the correct approach then feeds into our position on the appropriate relief, and we say the appropriate remedy is for the summary judgment application to be remitted to the information review hearing, and there was no need for it to be left till trial. So, my lords, unless I can help you any further, they're my submissions in support of my appeal.
At the moment, the information review hearing, you told us, is 3 days in
November. Yes.
If the summary judgment application were to be remitted, so that had to be dealt with as well, what impact on the time estimate?
Well, our original estimate was 3 days. Justice Robin Knowles refused to expand it once they issued their application. We actually dealt with all aspects of the case in 2.5 days. The other side will say they didn't have enough time to respond to the summary judgment application, but that was the way they decided to proceed with their main application. I suppose to be on the side of caution, possibly another day. Do you mind if I just look behind me?
Go ahead.
Be on the safe side, I would say 4 days.
Right, thank you very much.
Thank you.
Thank you. Yes, Mr. Contestant.
Grateful, my lord. What I propose to do, subject to your lordship, is to begin by saying something very briefly about 5 factual findings made by the learned judge, which are no longer challenged, and which we respectfully submit are important to the legal analysis of both the claimant's appeal and our cross appeal, not least because the effect of those findings, and this point was put to my learned friend by the court, is that some of my learned friend's grounds of appeal may actually be academic. I want to start briefly with the facts. Once I've done that, I'll deal with my learned friend's grounds of appeal in turn.
I just say, because of noise I've got over here,
Yes.
and I'm a bit further away from you, I'm finding it a bit difficult to hear you.
I'm very sorry, my lord. I was simply saying, I'll just say it again. I was saying that I was proposing to begin by identifying 5 factual findings made by the learned judge, which we would suggest are important both to the legal analysis and in identifying whether some of my learned friends' grounds of appeal actually arise, in the sense, are there anything more than academic? The 5 factual points that we would highlight are as follows. First, the claimants deliberately attempted to obtain the defendant's privileged information. Second, the claimants made that attempt for the purpose of using any information they might obtain to gain an advantage in this litigation. Third, sensitive information was in fact obtained by the claimants from X. Fourth, the claimants reviewed that information once they received it from Black Cube. And when Ennio Law, the claimant's former solicitors, refused to do likewise, the claimants sacked Ennio. Fifth, the claimants then sought to take the benefit of that information to gain an advantage in this litigation, not only by seeking summary judgment, but also by participating in without prejudice discussions with the defendants, in which their negotiating position, unknown to the defendants, was informed by the Black Cube evidence. Now,
Is that last one in the judgment?
yes, my lord, I'll take your lordship to it, but it's para 34,
Okay,
and it's
so-
picked up in 64 as well. It's a point I'll come back to. Now, of those 5 points, I don't need to say anything about points 1 and 2, which go to what did the claimants attempt to do and what is the purpose for which they did it. Your lordships have seen in the judgment the underlying evidence on the basis of which the learned judge made those findings of fact, and permission to appeal was refused by my Lord Justice Mates. But I do want to say something about points 3, 4, and 5, partly because they go to what we would suggest is an important point that was put to my learned friend at an early stage in his submissions by my Lord Justice Phillips. Let me start with point 3, which concerns the information the claimants actually got, whether it's privileged or not, what as a matter of fact did they actually get. Now, there is, of course, a dispute between the parties as to whether the information is privileged or not. And I will come back at some stage to explain why, contrary to what my learned friend was suggesting, there are actually serious difficulties in the claimant's attempt to invoke the iniquity exception. But the point I wanted to make at this stage is a narrower, factual one, which is that the claimants in fact obtained from X sensitive information about this case, and a lot of it. As to how much they got, the recordings of the covert meetings with X run to about 6.5 hours. And as to what they got, the learned judge recorded, just to give the court a reference, this is at para 5 and para 27, subparagraph 3 of the judgment. The claimants got information about the defendant's litigation strategy, settlement strategy, the merits of the claim, and the defenses to the claim. But I want to give your lordships a flavor, if I may, of some of the questions that the claimants actually asked X. And can I invite the court, please, to go to the supplemental bundle, tab 21, page 369. So this is the witness statement of Mr. Mascarenhas of PCB Byrne, who replaced the defendants from the solicitors after this all came to light. And if we could go to paragraph 15, please, that's at page 378. At paragraph 15, Mr. Mascarenhas says, there can be no doubt that Black Cube was seeking to obtain privileged information, not limited to potential matters of evidence, but about litigation strategy and perception of merits that could only have been intended to give the claimants an unfair advantage. Then over the page, he identifies some of the questions. And can I invite the court, please, to read subparagraphs A through to E at the top of page 379. Those are verbatim quotations of the questions that X was asked. Now, because we are not sitting in private, I won't read paragraph 16. But in that paragraph, Mr. Mascarenhas identifies some of the answers that the claimants obtained to these questions. And I would respectfully invite the court in due course to read paragraph 16. At this stage, can I just show you, by way of example, 2 or 3 of the subparagraphs? Picking it up at subparagraph C.
We'll be careful in the way that you are doing about the information that comes forward, but the questions at paragraph 15 presumably are not confidential.
No, I was just.
I just want to be.
That's absolutely
clear.
Right.
Thinking ahead, for example, in case there's any need to refer to things in the judgment.
That's absolutely right, my lord. In fact, my recollection is that we refer to the questions in public at the hearing below for precisely that reason.
Yeah. Okay.
So I wanted to show you, lordships, just 2 or 3 examples. Picking it up at subparagraph C at the bottom of 379, if I could ask the court to glance at that, please. It continues over the page. And then subparagraph E on the same page. Then subparagraph J on page 381. And finally, subparagraph K, also on page 381. So that's why the third of my 5 points is that whatever the evidential status of this information, what seems clear is that the claimants got sensitive information about this case, and rather a lot of it. That takes me to point 4. And that concerns the claimant's decision to view the recordings once Black Cube provided it to them. Because the sequence of events, as we understand it, is this. I'm taking this from the claimant's own evidence. The claimant's evidence is that after Black Cube finished their investigation, they sent the recordings of the covert meetings directly to the claimants through a secure, I think it's called FTP, a file transfer system. Now, at that stage, so when Black Cube sent the recordings to the claimants were represented by Enyo. And as the learned judge noted at paragraph 29 of his judgment, I don't think we need to turn it down, but it's co-bundle, tab 8, page 155. Enyo refused to look at the video files or to listen to the audio files. There's no challenge to that factual finding. And for good measure, Enyo have independently confirmed subsequently that they were not privy either to the instruction of Black Cube or to any material obtained by Black Cube. So Enyo have never seen any of this. And just to give the court a reference, that is in a letter from Enyo dated the 8th of May 2025, which is supplemental bundle, tab 31, page 492, paragraph 7. Now, what we do know, my lords, is that LK Law were instructed by the claimant on the 31st of January 2025, while Ennio was still on the record. And we know that because that's what the claimants told us in their skeleton argument for the hearing below. LK Law agreed to view the recordings. A few days later, Ennio are sacked, and LK Law come on the record on the 6th of February 2025. So that's the chronology, as it were. Now, there is a point of principle which I'll deal with when I address the cross appeal about the duties of a solicitor in these circumstances. But there is at this stage a simpler factual point that I wanted to make. As your lordships are aware, the claimant's case is that the information they got is not privileged, essentially because the iniquity principle is engaged. And we dispute that. But what is significant about the claimant's attempt to invoke the iniquity exception is that they seek to invoke it solely by reference to the contents of the recordings and not independently of the recordings. In other words, it has never been suggested that the iniquity exception was considered by the claimants to be engaged at the point they pressed the play button, as it were, on their computer when the recordings come to them from Black Cube. In other words, before they made the decision to view the recordings. I mention that because it would appear to follow from that the claimants, knowing that the recordings sent to them by Black Cube contained a conversation with the defendant's solicitor about this case, then made a decision to view the recordings, press the play button as it were, despite having on their own case no reason to believe at that stage that the recordings would be anything other than privileged. Now, the example that occurred to me to test this point is this. Suppose that the claimants instruct Black Cube to place a covert listening device in room 37, which my team is using as the breakout room. And let's say that the recording picks up a discussion that my solicitors and I have about how we think this appeal is going, the sort of discussion people have during breaks in a hearing. Suppose that after listening to that discussion, the claimants contend that the discussion is for one reason or another not privileged. And let's assume that that is true. But even if it were true, it could not in our submission justify either the decision to place the recording device in the breakout room in the first place, or the decision to listen to the recording once it is obtained, because at that point in my example, the claimants must have believed that the conversation to which they were about to listen would be privileged. If that is the right analysis of the example, then it carries over to our case, because as I submitted a moment ago, it's never been suggested that the iniquity exception is engaged independently of the contents of what X told the claimants. And this goes to a point my Lord Justice Phillips put to my learned friend at an early stage, which was, it may turn out in a particular case that some conversation is not privileged because the iniquity exception is engaged. But at the point you seek deliberately to breach privilege, you can't know that. And that, in our respectful submission, is a very important point. It's reflected in some of the authorities I'll take the court to. Because the current state of the authorities appears to be, for precisely that reason, that it is improper to view not only a document that is known to be privileged, but also a document that is apparently privileged. For instance, if I get by email a solicitor-client communication from the opposing party in litigation, the authorities are very clear, I can't read it. Even if, having read it, it turns out, for some reason, that the document isn't privileged, it's improper to make that decision to read. The rationale for that may in part be prophylactic, which is if the law were not to that effect, then it would be open to people to look at apparently privileged documents in the hope that, having looked at it, you can find some reason why it's not actually privileged. But if they get that wrong, then there's no way to undo the invasion of privilege because it's already been read and it can't be undone. Now, that's the fourth of my 5 points. And the reason why I make the point, it's perhaps significant for two separate reasons. The first is that at paragraph 64 of his judgment, we can call that out, that's that co-bundle tab 8, page 131. The learned judge found that the claimant's abuse was compounded by their receipt of the illicit information, their review and retention of it as illicit knowledge, their new solicitor's review and retention of it extraneous and perhaps contrary to any applicable procedural scheme or regulatory framework, and the uses made of such illicit knowledge to date, as summarized in paragraph 34 above. And paragraph 34 is the passage I mentioned earlier in response to my Lord Justice Mayers, which refers to the use of the information at the without prejudice discussion. Now, there's a linguistic point against me, which I'll identify and deal with in a moment, but it's a significant passage there, paragraph 64, because it shows that the learned judge's finding of abuse is actually not based solely on the quality of the claimant's conduct, but also on various things that happened thereafter, which include the actual deployment of the information, whether privileged or not, in seeking summary judgment, the use of the information and without prejudice discussions, and indeed what we would submit is the improper decision to review it when the recordings are sent to them. So that's the first reason why we would submit is significant. I mean, the point against me, which I need to deal with, is the learned judge at paragraph 64 uses the word compounded. So it might be said that this is not a finding that, it might be said that that shows that he made a finding of abuse independently of this and that this merely aggravated the seriousness of the abuse. But, my lords, what we'll say about that is if we go back for a moment to page 130, just above paragraph 59, the heading of this section of the judgment is, does the claimant's unethical behavior involve or constitute an abuse? So the learned judge is dealing not with sanction, but with the existence of an abuse. And one of the things he takes into account in making the finding of abuse is what he sets out at paragraph 64, which is not confined to his assessment of the conduct of the claimants independently of anything that happened thereafter, but instead takes into account the receipt of the information, the review of it, etc. So that's the first reason why this point is significant. The second reason is it gives rise to an interesting point of law, which I'll come to probably tomorrow. But just to foreshadow it, in any case in which it is said that the iniquity exception is engaged, not just in our case, but more generally in any case, the court has to decide whether the relevant merits test, the iniquity is established to the relevant merits test, which after the Al-Sadek case is the balance of probabilities. So if you want to invoke the iniquity exception, you have to identify an iniquity, something that constitutes an iniquity, and you have to show on the facts that that iniquity actually happened on the balance of probabilities. Now, the current state of the authorities, albeit I would accept only first instance, is that in making that decision whether the iniquity exception is engaged, the court will not look at the putatively privileged material save in exceptional circumstances. In other words, you've got to show independently of the documents to which you say the iniquity exception applies that the relevant merits test is satisfied. And in many cases, there will be no difficulty about doing that because if a fraud has been perpetrated and there's evidence of it, even before you get to any privileged communication or some other iniquity has been perpetrated and there's evidence of it, you can establish the iniquity independently of the documents that you say are no longer privileged. But what the courts have said is, save in exceptional circumstances, you can't do it by looking at the document itself. And the rationale for that is, in part, the prophylactic point I mentioned earlier, which is, if one allows that, then having looked at it, the court may say, well, actually, the iniquity isn't established. But that, at that point, the privilege has already been invaded and can't be undone. But the reason I mention this is, and I'll develop the point tomorrow when I show your lordships the authorities. If we are right about this point of principle, then the iniquity exception does not apply even on the claimant's own case, because as I submitted earlier, it is only sought to be invoked by reference to the contents of what Mr. X said.
Is that a distinction from the Benkel case, which is mentioned in paragraph 62? It looks as if in that case there was a belief, or perhaps grounds for thinking, that the material targeted was going to engage the iniquity exception.
Can I just check Benkel and come back to your lordship?
Yes.
I just need to remind myself of whether that was the position.
Just from the summary of the facts,
Indeed, yeah.
it looks as if sham legal structures and so forth might
Yeah.
have given rise to that understanding.
I'll just look at the authority once again if
Yes,
I
of
may
course.
come back to your lordship. But
Do we have it incidentally in our bundles?
Benkel, I don't believe we do.
Okay.
Yeah. But the key authorities on this, and I'll take your lordships to it tomorrow. It's a case called CNC, Mr. Justice Munby, and a case called BBGP, which say that there's an exceptional circumstances test to look at the putatively privileged documents in the context of the iniquity exception. And this point of principle was taken below. The learned judge did not decide it, but he refers to it in his consequentials judgment, just to give the court a reference to it. Paragraph 10, subparagraph 3, page 139. He says that my suggested estimate for the information review hearing is 2 to 3 days. Then he says, there may be threshold points to consider. For example, the defendants have contended that it could never be appropriate for the solicitors who obtain potentially privileged material to conduct the sort of review as done by the claimant's new solicitors. The learned judge, with respect, is right to describe this as a threshold point, because if we are right about this point, one never gets into the question of whether the iniquity acceptance is engaged on the facts, because it's never been sought to be invoked independently of the contents of the evidence. That's what I wanted to say about the facts. I was going to turn next, if I may, to the grounds of appeal. But I'm going to try to be very short about this, partly because I ought to reserve the bulk of my time for our cross appeal, but partly because much of the ground was covered in the points that the court put to my learned friend. I'll start with ground 2, just because that seems to us to be the logical order in which to consider this. We have 2 answers to ground 2. First, we say that ground 2 is academic and does not arise. Second, if ground 2 does arise, the learned judge was right to say that it is possible for an abuse to arise solely out of the quality of a litigant's conduct, irrespective of its impact on the proceedings. Now, my lords, in relation to the first of those points, why we say this ground of appeal is actually academic is, if you just stand back, the claimant's proposition under ground 2 is that the quality of a litigant's conduct cannot of itself give rise to an abusive process. That's legally impossible, they say, and that something more is required, such as the impact on the proceedings. But the question one then has to ask is, on the claimant's case, what is that something more? What is it that they say is required in addition to the quality of a litigant's conduct to turn it into an abuse? And it seems to us it can be one of 2 things, conceptually. First, the claimant's case might be that a litigant's conduct cannot amount to an abuse unless it also jeopardizes the fairness of the trial in the narrow sense. That is to say, in the sense of jeopardizing the court's ability to make a safe or reliable determination of the substantive issues before it. Just in the interest of clear terminology, I'm going to call that conception of the fairness of a trial as the fairness of a trial in the narrow sense. If a determination were to be made of whatever the dispute is about, would that be a safe or reliable determination? The claimant's case might be that conduct alone cannot constitute an abuse unless it jeopardizes the fairness of the trial in that sense. So that's one possibility. The second possibility is that a litigant's conduct can amount to an abuse, even if a fair trial in the narrow sense is still possible, but only if that conduct has had some other impact on the litigation, short of jeopardizing the fairness of the trial in the narrow sense. For example, by requiring costs to be incurred or judicial time to be used in investigating the abuse. There are passages in my learned friend's skeleton argument which suggest that what they mean is the second possibility, and there was a sense of that in the course of my learned friend's submissions this morning as well. But if that's my learned friend's case, then ground 2 is academic, essentially for the reason that was put to my learned friend by my Lord Justice Males, which is nobody disputes that the conduct which the learned judge characterized as abusive has already given rise to a 2.5-day hearing below, a 3-day appeal in this court, a further 3-day...
Well, we're hoping it may not be the full.
Well, indeed, I was actually just about to say 3 days subject to your lordships. And a further 3-day information review hearing, in addition, of course, to the half-day directions hearing before Mr. Justice Robin Knowles last summer. So, and it's not just costs and judicial time. I showed your lordships paras 34 and 64 of the learned judge's judgment, which point out they've actually got information, they've actually deployed it, whether it's privileged or not doesn't matter for this purpose, they've actually deployed it in seeking summary judgment, and they've used it in without prejudice discussions. So if what they're going to embrace is the second version of putting the case, it's academic, ground 2. And so where one gets to, it seems to us, is ground 2 will only raise a point that's not academic if what the claimants are saying is that the conduct of a litigant can't amount to an abuse unless it jeopardizes the fairness of the trial in their narrow sense. In other words, unless it prevents the court from making a safe or reliable determination of the substantive issues. If that's their case, I would accept it's not academic, but it's contrary to Supreme Court and Court of Appeal authority. Indeed, if there were a rule that you can never have an abuse unless it jeopardizes the fairness of the trial in the narrow sense, then, my lords, it ought to follow that you can never strike out a claim as an abuse after the trial if you know that the trial was a fair trial. That ought to be conceptually impossible on this version of my learned friend's case. Because once you've had the trial and you know that it's a fair trial, ex hypothesi, that conduct has not jeopardized the court's ability to make a safe or reliable determination of the issues. But there's Supreme Court authority, the Summers case, which confirms that the court does have that power, albeit that it is to be exercised only in exceptional circumstances. But it's not just Summers. This version of the claimant's case is actually inconsistent, we would suggest, with the disposition of our nominees on its own facts. And I just want briefly to explain why we say that. My learned friend helpfully took the court through the case, so I can make my points relatively shortly. But what happened in that case? It was a standard unfair prejudice petition, if I can put it like that. So you have two rival camps in a company who've fallen out, and there's a dispute about who should control the company. Now, Mr. Tobias, who was essentially the controller of one of the petitioners, our nominees, he forged 6 letters during the disclosure stage of the litigation. He got caught out, apparently because he used a telephone code which didn't exist on the date of the purported letter.
It was the 020.
Indeed.
Yeah.
And I think either at first instance or on the Court of Appeal, there's an observation that but for that, he may have got away with it. But anyway, it all came out, and there were two separate strikeout applications. So the respondents applied to strike out the petition shortly before the commencement of the trial. They lost because the judge found that the fairness of the trial, in what I've described as the narrow sense, wasn't jeopardized. But he gave the respondents liberty to renew the strikeout application at the trial itself, and permitted them to cross-examine Mr. Tobias about the extent of his forgeries. Predictably, that application was made. The judge found that Mr. Tobias had lied about the forgeries in cross-examination, but he refused the second strikeout application on the ground that a subset of the pleaded allegations was not infected by the forgeries and therefore was still capable of a fair trial in the narrow sense. And we can see that if we look at the first instance judgment, it's in the hard copy, Authorities Volume 1. Tab 7, page 114, so we're in the first instance judgment at this point. So at the top of, it's page 114. Picking it up at the top of the page, paragraph 54, the learned judge says it was the respondent's submission that any case which depended on breach of reasonable expectations of the petitioner as derived from the 1994 agreements, pursuant to which Nigel and Lorraine joined body care, cannot receive a fair trial, or at least there's a substantial risk it can't receive a fair trial, because Nigel's forgeries have placed in question the documentary evidence on which the court could base its conclusions. I accept that submission subject to the qualification that there would be no substantial risk to a fair trial of a case which was not based on the 1994 agreements, or to the extent that it depended on the terms of those agreements, the relevant terms are not an issue between the parties. So the trial judge refuses the second strikeout application on the ground that a fair trial of a part of the petition is still possible. But this court allowed the respondent's appeal and struck out even that part of the petition. And it did so, as one would expect, fully alive to the distinction between what could and could not be the subject of a fair trial in the narrow sense. I say that because it's referred to in Lord Justice Chadwick's judgment, page 134. At paragraph 42 at page 134, in Roman 1, 2, and 3, Lord Justice Chadwick identifies the three different grounds on which the unfair prejudice petition had been pleaded. One was contrary to the 1994 agreement, two was contrary to legitimate expectations, and three was essentially misuse of corporate powers. At 43, it says, the judge held that there was a substantial risk that there could not be a fair trial insofar as the complaints of unfair conduct were based on one or two, acting contrary to the 1994 agreement or the petitioner's legitimate expectations. And then at 45, if we look just below letter E, page 135, it was on that basis, but only on that basis, that the complaints could be brought within three, acting in any event unfairly in the conduct of the company's affairs so as to prejudice the petitioners. So when one looks at Lord Justice Chadwick's reasoning, it's important to remember that this court was dealing with an application to strike out a claim which the judge had found could be the subject of a fair trial in the narrow sense. But nonetheless, this court struck it out. So even before one gets involved in a close textual analysis of individual phrases used in the judgments, the outcome in arrow nominees can't be reconciled with my learned friend's submission if this version of the case is what is advanced, that you can never have an abuse or never strike out a claim as an abuse if a fair trial in the narrow sense is still possible. So one is then driven back to the alternative way of putting the case, which is, yes, you can strike it out if a fair trial in the narrow sense is possible, but only if there's been some other impact. But if that's the case, then it's academic for the reasons I gave earlier. So subject to the court, I wasn't going to say anything more about ground 2. I wasn't going to deal with Daduri and Hamilton. I'll pick up some of those cases when I deal with the cross appeal. But it does seem to us it's either going to be academic or contrary to Supreme Court authority. But before I leave ground 2, I want very briefly to say this, my lord. Suppose I'm wrong and this is not academic. Then the question is, did the learned judge make an error of law at paragraph 44 when he said, of his judgment, when he said that there are two broad categories of abuse of process. One concerns solely with the quality of behavior. Now, there are two preliminary points I'd make about that. The first is the learned judge here is only saying this is possible. He is not saying that in every case, an abuse will arise solely by reference to the quality of a litigant's conduct. And the second, to pick up a point my Lord Justice Foxton put to my learned friend, it is implicit that there must be some nexus between the conduct in question and the finding of abuse. I mean, in our skeleton, we give the example of a litigant who commits a crime in their private life. Nobody is suggesting that that without more is an abuse. But the target my learned friends have to hit is they have to say, if a litigant does something in that capacity with some nexus to the litigation, it is nonetheless impossible as a matter of law for that conduct alone to give rise to an abuse, independently of its impact on the litigation. That's really the target that my learned friends have to hit to establish that the learned judge erred in law at para 44. And in our respectful submission, there's a very simple reason why the claimants can't hit that target. And it is that an exclusionary rule of that kind is inconsistent with the conceptual nature of abusive process. I mean, my learned friend was right to say that the classic exposition of abusive process is that of Lord Diplock in the Hunter case, where Lord Diplock identifies two broad categories of abuse: manifest unfairness to a party or something that would bring the administration of justice into disrepute. But Lord Diplock goes on to say that no attempt should be made to define what can or can't amount to an abuse in particular circumstances. Indeed, even Lord Diplock's formulation may not be exhaustive, and that point's been made in the authorities. And what we would respectfully suggest has gone wrong in the claimant's analysis of ground 2 is they've looked at our nominees and they've assumed that that is an exhaustive statement of what can or can't amount to an abuse. But our nominees is not exhaustive any more than Hunter is exhaustive. And the whole point of this, about this area of the law, is that you don't have conceptual limitations on what can or can't amount to an abuse. It is a case specific rather than a conceptual question.
But just look at stepping back a little bit from all this.
Yeah.
Is it the right way to go about this for the judge on a summary judgment application to get into a detailed analysis about whether there's an abuse of process with a view to considering whether, as a sanction, he should strike out a summary judgment application? And that, to me, I've certainly not come across it before.
No.
And it doesn't seem to me like a very sensible use of judicial time or, quite frankly, brain power, when there are much simpler routes to not giving summary judgment in a situation where the judge considers that the claimant has not acted properly, and where that conduct
Yeah.
One might say requires exposure to the glare of publicity, or I mean, it seems to me to be a quintessential compelling reason not to grant summary judgment. So why are we going into contortions over abuse of process?
No,
in order to decide whether or not you do the rather extraordinary thing of striking out an application for summary judgment.
I understand exactly what your Lordship's putting to me. Two responses, if I may. First, as your Lordship says, it would have been more straightforward, perhaps, to say that the compelling reasons test under CPR 24.2 satisfied, instead of striking out the summary judgment application as a sanction. I wouldn't disagree with that.
But you haven't put that in by way of respondent's notice, have you?
No, I haven't put it in by way of response.
You have your eyes on a bigger prize.
Indeed, my Lord. That was going to be my second point. One of the oddity about these two appeals is both my learned friend and I are submitting, but for opposite purposes, that the learned judge was wrong to identify the possibility of striking the summary judgment application out as a sanction for the abuse. I say that that was wrong, and I seek to say what he should have struck out is the entire claim.
But you both could lose.
We both could lose, of course.
And then we have to decide what to do.
Indeed. And so one of the main topics I'm going to address when I come to the cross appeal, hopefully today, is what is the appropriate re-exercise of your Lordship's discretion if your Lordships were to form the view that in one or other respect the learned judge is erred.
And I suppose if the only application before the judge had been the summary judgment application, then the simple answer, refuse summary judgment because of other compelling reasons, would be open to him and a complete answer. But as your application to strike out was before him, he had at least to decide what to do with that.
Precisely so. Indeed, one of the proposals we made to the other side before the hearing, because we were very concerned about the time estimate, was to say, why don't we use the hearing just to hear the strikeout application and adjourn the hearing of the summary?
Yes, I bet you did.
And I bet they didn't like the suggestion.
They didn't like it at all. We got a vigorous letter back pointing out several reasons why we were said to be wrong. In the event, both applications were heard. But with respect, I don't disagree at all with what my Lord Justice Phillips put to me. I mean, obviously I say if I fail on the cross appeal, that the learned judge was entitled to strike out the summary judgment application. That's very much my fallback is. As my Lord Justice Foxton put it, the real prize, and what we say the learned judge should have done, is to strike the claim out. But I appreciate I lost on that point below, and the burden's on me to persuade your Lordships that that should be revisited, and I'm going to endeavour to do that.
At the moment, you're not addressing your cross appeal, as I understand it.
No.
So we've got to address the appeal.
Yeah.
And the question is, if the appeal succeeds, and let's leave aside for a moment your strikeout application.
Yeah.
Your strikeout application. What happens? And what's your submission there?
Our submission is, and I appreciate this is why your Lordship asked me about response notice. Our submission is that the learned judge was right to refuse summary judgment, if I can put it that way, even if he wasn't right to refuse it in the form of a sanction for abuse. I don't need a respondent's notice to take that point, because if you think about the stages to the analysis, we only get to this if the claimants persuade your Lordships that the learned judge made an error of law or there's some other factor that vitiates his decision to strike out the summary judgment application. At that point, your Lordships would be re-exercising a discretion, and I'm simply making a responsive submission, which I can do without a respondent's notice, that in re-exercising the discretion, summary judgment should be refused because there's a compelling reason to do it. That's how I would see the point working. That's why I don't need a respondent's notice, because we only get to this if they're right on one or other of their principal grounds of appeal, ground 2 or ground 3. But, I mean, I don't want to say something which, when I get the court's judgment, may turn out to be bold and overly optimistic in equal measure. But it does seem to us, standing back, the real issue on these appeals is not so much was the learned judge right to make the finding of abuse, as it is what sanction should be imposed and when should a sanction be imposed. That's the real battleground as we see it. Because ground 2, for the reasons I've endeavored to identify, is either academic or contrary to authority. And that then takes me to ground 3, which I can address even more shortly, I think. Now, the starting point, actually, my lords, for ground 3 is that a finding at first instance that some conduct amounts to an abuse does not involve the exercise of a discretion, but it is an evaluative assessment. And that's common ground. It's also common ground that this court will interfere with that evaluative assessment only if the judge below made an error of law or took into account irrelevant factors, things of that nature. I say it's common ground because it's accepted in paragraph 9 of my learned friend's skeleton argument. And there are also numerous authorities to that effect. Indeed, as my Lord Justice Phillips put it in the Skurikin case, the judge's evaluation of whether some conduct amounts to an abusive process carries considerable weight in this court. And just to give the court a reference, Skurikin is Authorities, Volume 2, Tab 31, page 774, paragraph 50. Now, since ground 3 is presented as an independent ground of appeal, one has to test it on the premise that ground 2 has failed, because otherwise ground 3 is not an independent ground. But if ground 2 has failed, then there is a category of abuse that is concerned solely with a litigant's conduct. And on that hypothesis, the first problem about ground 3, we would suggest, is that it is simply an attempt to re-argue the abuse issue in this court without attempting to identify any error of law or irrelevant consideration that is set to vitiate the learned judge's evaluative assessment. Or to put it another way, the only alleged error of law is ground 2, but we only get to this if they're wrong about ground 2. Indeed, it became apparent from the way my learned friend presented ground 3 this morning, which was to invite the court to compare the claimant's conduct in this case with the conduct in Rakia on the one hand and Raja on the other, that the claimants simply disagree with the learned judge's evaluative assessment, but haven't identified any error of principle. And that's actually the short answer to ground 3. But there is in our submission also a longer answer if we need it, which is even if one is looking at this entirely afresh without giving any weight to the learned judge's assessment, we would respectfully submit that the learned judge was right to characterize what the claimants did as an abuse. But I'm going to pick up that point, if I may, when I deal with the cross-appeal, just to avoid repetition, because it's also central to why we say the appropriate sanction for it is to strike it out. And in that context, I'll deal with the authorities my learned friend cited, such as Rakia, which is his principal authority. So that's ground 3, and your lordships have my submission that in any event, what the learned judge found to be abusive was not merely the deliberate attempt to obtain privileged information, but the entire package of conduct which I identified earlier, including the deployment of the material, the decision to review the recordings, and the participation in the without prejudice discussions. And when one adds that to the mix, it's just even more difficult to disturb the learned judge's evaluative assessment that that whole package of conduct is an abuse. So that's ground 3. I don't need to say anything about ground 5 because it is parasitic upon 2 and 3 and will not arise if those grounds fail. I can take ground 6 pretty shortly. What my learned friends say under ground 6 is that the learned judge was wrong to impose any sanction for the abuse before deciding the issues that he deferred to the information review hearing. But just before the short adjournment, I understood my learned friend to accept that there is conceptually a distinction between an attempt and an outcome. It's possible deliberately to attempt to obtain privileged information, even if in the event you draw a blank and you don't get any information at all, or you get information but it turns out not to be privileged. And we only get to ground 6 if they've lost on the prior grounds of appeal. So the hypothesis at this stage of the analysis must be that attempting deliberately to obtain privileged information is an abusive process, or that the whole package of conduct I identified earlier is an abusive process. But on that premise, there's no reason why the learned judge was not entitled to impose a sanction for it. There is obviously a debate about what the right sanction is, but there isn't, we would suggest, a debate about whether the learned judge was entitled to impose a sanction.
Well, and when he should impose it.
When he should impose it. So that, exactly. So I think my learned friend's main point, this came up a number of times in his submissions. He said, you have to have regard to all the circumstances before you impose a sanction. Now, the difficulty about that submission is that the only two possible circumstances which are relevant to the question of sanction are, one, is the information actually privileged? And two, what impact has the information had on the fairness of the trial or more generally on the litigation? I don't understand it to be suggested that there is any further circumstance which could even conceptually bear upon the question what sanction should be imposed. Now, let's assume for a moment, taking the claimant's case at its highest, let's assume both of those circumstances in the claimant's favor. So assume that the information obtained is not privileged. Assume that a fair...
When you say not privileged, you mean not privileged because it is iniquitous?
Yes.
Or
Which is
public domain.
Or public domain. It's one or other of those points that my learned friends take. They say some of the information...
What kind of information would be in the public domain?
So they say that some of the... I need to be slightly careful in what I say, but they say that some of the information that was revealed by X can be identified in some witness statements in the litigation. And therefore, it can't be privileged because it has crossed the line and is no longer confidential. But it doesn't apply to the majority of what was revealed. Indeed, I think this is a point that that was put to my learned friend. Even the iniquity...
So not so much in the public domain as public between the parties.
Public between the parties, precisely. So my submission is, let's assume both of the posited circumstances in the claimant's favor, information not privileged, and assume that it does not have any impact on the court's ability to conduct a fair trial in the narrow sense. If on those assumptions, the appropriate sanction is to strike the claim out, there's no reason why the judge shouldn't do it now, or why this court shouldn't do it now. It's obviously a big if, in that if I fail on my cross appeal, then the court will have decided that's not...
What about what about the factor that there may be found that your clients perpetrated a horrendous fraud on the claimant?
Indeed, and that is one of the big topics I'm going to deal with when I come to the cross appeal. But I give your lordship, just to foreshadow it, my two answers to that. Our first submission is that is legally irrelevant to the exercise of the discretion as to what sanction to impose, and that's a big topic I need to deal with. Our fallback submission is, if it's relevant, it's only relevant where the fraud is either proved or possibly where you have a very strong case on the facts, which they don't. Again, we're either right or wrong about that.
At the end of a trial, it will have been proved or not proved.
Yes, but if the question of, if an abuse is committed before the trial and the court is deciding what sanction to impose, I mean, there's a spectrum of possibilities. One possible view is that the substance of the claim is irrelevant to the choice of sanction. Let's assume for a moment that that is right. In that case, we don't need to form a view about the merits in order to impose a sanction now because it's irrelevant. Second possibility is that it's relevant, but you have to satisfy some kind of merits test before it can reduce the sanction that would otherwise be imposed for an abuse. And then the question would be, what's that merits test? Is it, you have to have a case to the summary judgment standard, you have to have a case which is a prima facie case of fraud, but we say whatever the merits test, they can't meet it on the facts. And I'll need to address that when I come to the cross appeal. But if I'm right about either that point or my fallback point, then this falls away, and all you're left with is the other two relevant circumstances. So I'm not trying to run away from it, my lord. There are obviously, when the court imposes a sanction for any abuse, it weighs various factors, some pointing in opposite directions. But there's always a prior question, which is this factor legally relevant? If the answer to that is no, it falls out of the mix. And if it is legally relevant, then the question is, has whatever merits test that applies to that factor been satisfied? And I'm going to seek to persuade the court that it's not. But if I'm right about all that, then ground 6 falls away. And if I'm wrong about that, I lose anyway. So in a sense, ground 6 doesn't really arise. That's what we say about ground 6. And ground 7, I'm going to take even more quickly. It's a procedural complaint that the learned judge deferred certain issues to the information review hearing without first raising that with the parties. But in truth, this collapses into ground 6 because the premise of both ground 6 and 7 appears to be that there's something inconsistent in what the learned judge did. In other words, in saying on the one hand, I can't now decide if the information is privileged. I can't now decide if a fair trial is possible, but also imposing a sanction. But there's no inconsistency in that. It may be wrong, but it's not inconsistent. And if it's not inconsistent, then these grounds of appeal don't add anything to the other grounds of appeal.
Well, it said that it was procedurally unfair because it was not raised with the parties. Does that not add something?
Well, I can see conceptually it adds something, but the learned judge's answer to that, he addressed that point in the consequentials judgment. He said that in his first judgment as a deputy, he learned the lesson, as he put it, that a procedural accord of that kind doesn't bind the court and that the court must do what is appropriate.
It's a due process issue, isn't it? That parties don't know that they need to make submissions on a particular outcome. If it's not raised with them, and the case is then decided on that basis.
Yeah, that's true, my lord. But the answer to that is that my learned friend himself said today that he made submissions on everything, on summary judgment, strikeout, iniquity, exception. So this is not a case where if there was any procedural unfairness, that has deprived the claimants of an opportunity to make whatever submissions they wanted to make. We say we didn't address the summary judgment application fully, but this is not my ground of appeal, it's theirs. So if one asks what's the consequence of the procedural unfairness, it's not clear there is any.
I suppose it would mean that if parties were other able, one of you, to rely on the judge's evaluative decision as to what the sanction might be, the deference an appellate court would normally show to that evaluation would be undermined if it took place without affording an opportunity to make submissions.
I can see that. And I mean, I can't run away from, indeed, I'm going to have to embrace when I come to the cross appeal that the court should go behind the learned judge's exercise of discretion. Because, of course, I say that he imposed the wrong sanction. But my submission on grounds 6 and 7 is that it became, if not common ground, it became apparent in the course of the hearing that there was not enough time to resolve everything. And the learned judge identifies some metrics at an early stage of his judgment, the number of footnotes and skeleton arguments, things of that nature. So the learned judge was in a position where he was able to decide certain points, and he wasn't able to decide some other points. But there's no reason why, when the judge is in that position, he should not decide what he can decide, leaving what can't be decided to be addressed at a further hearing. I mean, the only possible objection to that course would be if there's some logical inconsistency between deciding set 1 and not deciding set 2, for instance, if they are interlinked. But my submission is they're not interlinked. And if we get to this stage of the analysis on the claimant's appeal, in other words, they've lost on all their prior grounds of appeal, then the premise is that these two sets of issues are not interlinked, in that once the finding of abuse has been made by the learned judge, he's entitled to impose such sanction as is appropriate for that abuse, assuming in the claimant's favor all the points that he's deferred to the information review hearing. Or to put it another way, and that's probably too complicated a way to put it another way, our case is that the information review hearing can only make matters worse for the claimant, not better. Because if the claimants win at the information review hearing, so then they will have established information not privileged, fair trial possible. But my case assumes those things in their favor. If they lose at the information review hearing, that can only increase the sanction, not decrease it. So
I'm not saying it's impossible. It's quite rare to sort of bank a bit of a sanction as you go, with the ability to move it up as a subsequent event. It's not generally across the law how we impose sanctions. I'm not saying it's not possible, but it's certainly unfamiliar.
No, I would accept that. I would accept that. It is unusual. But I'm not sure it follows from that in the circumstances of this case, the hearing having taken the course it did, that the learned judge's approach was an error which justifies setting it aside on that ground alone. Indeed, another way to put it may be that if the claimants fail on grounds 2 and 3, just thinking about the waterfall of issues and how they interrelate, if they fail on grounds 2 and 3, then they can't overturn the finding of abuse. All that's then left is sanction. So then the logical course may be to consider the cross appeal, because if my cross appeal succeeds, game over. If my cross appeal fails, only then would the court have to decide what, if anything, to do with the summary judgment application.
Right, is that what you want to say on the appeal?
I just need very quickly deal with grounds 1 and 11, which I can literally do in a minute. Under ground 1, the claimants say the learned judge was not entitled to strike the summary judgment application out as a sanction for the abuse. Your lordships have the submissions I made about that. Even if that's right, he had discretion under CPR 24.2 not to enter summary judgment. And there's an authority we have put in the supplemental bundle called Allied Fort, just to give the court a reference. Supplemental authority, stamp 3, page 74, paragraphs 100 to 101, where this court makes the point that even before you get into the test under CPR 24.2, the court has a discretion as to whether or not to engage in the exercise of summary determination. So even if the learned judge was wrong to strike it out as a sanction, he could have simply declined to engage in that exercise, or engaged in it but found that there's a compelling reason for a trial, as my lord put to me, in which case we get to the same outcome. Subject to the court, those are my submissions on the appeal. Now I was going to turn to the cross appeal.
Yes, thank you.
I accept at the outset that in deciding what sanction to impose for the claimant's abuse, the learned judge exercised a discretion. And that means that there are two distinct issues for your lordship's determination on the cross appeal. Issue 1 is whether the learned judge's exercise of his discretion was flawed on one of the recognized grounds for challenging the exercise of a discretion, such as error of law, failure to take relevant factors into account, taking irrelevant factors into account. And that issue, issue 1, will require a close analysis of the 5 reasons given by the learned judge, I think at para 78 of his judgment, which I'll come to in due course, for declining to strike out the claim. If we fail on issue 1, in other words, if your lordships are not persuaded that the learned judge's exercise of his discretion was flawed, then I accept that my cross appeal will fail. If we succeed on issue 1, in other words, if your lordships are persuaded that the exercise of the discretion was flawed, we don't win automatically, but the discretion would fall to be re-exercised by this court entirely afresh. And the question would then become, how should it be re-exercised? And that is issue 2 on the cross appeal. That, as we see it, is the analytical framework for the cross appeal. In terms of the batting order for my submissions, what I was proposing to do, subject to your lordships, is actually to start with issue 2 after making some introductory observations, and only then to deal with issue 1. The reason for that slightly unconventional batting order is that some of my submissions under issue 2, namely how should the discretion be re-exercised if it falls to be re-exercised, raise points of principle, not fact. And if we are right about those points of principle, that would then mean that the learned judge's exercise of discretion was vitiated by errors of law. So there's a close relationship, in this case, not in every case, but in this case, between issues 1 and 2.
I think that will make it important as you go through issue 2 that you flag those points that are said to vitiate at the stage of issue 1.
Absolutely, my lord. And the other reason why I want to start with issue 2 is, if your lordships were to form the view that the learned judge was wrong to strike out the summary judgment application as a sanction for the abuse, then it must follow that the exercise of the discretion was vitiated on that ground alone, even if I'm wrong about all my other issue 1 points. Because the learned judge plainly did not think that indemnity costs alone, which is the other sanction that he imposed, would be a sufficient sanction. He thought something more was required, and his something more was the striking out of summary judgment. If your lordships take the view that that second element was wrong, then we would have thought we are straight into issue 2.
Were any other options canvassed, in particular the discharge of the freezer?
Yes, it was, and that has also been adjourned to the information review hearing. I mean, without wanting to get into the archaeology of all this, what happened was that we issued a further application seeking in the alternative to a primary case of strikeout the discharge of the freezer as a fallback. And that was issued, I think it was in September 2025 after PCB Byrne took over. And the learned judge has adjourned that application, if it arises, to the information review hearing. But I make that point because my Lord Justice Foxton is right. It's important when we go through issue 2 to work out, in relation to each of my points, do I have to hit an enhanced threshold? Or is it sufficient for me to persuade your lordships that the right thing to do is to strike the claimant? And the answer to that will turn on whether the exercise of the discretion is vitiated.
I'm just trying to get my head around. So in terms of sanctions, strikeout was clearly put before the judge and he ruled on it. Striking out summary judgment, there's a dispute about whether or not that was canvassed as a sanction for the parties to argue about. And discharging the freezer was put over to a different hearing.
Yes, on the striking out the summary judgment, we'll check the transcript, but certainly my recollection was, my submission to the learned judge was that that is not capable of constituting a sanction. That's the point I need to develop. And I think my learned friend was also submitting that the summary judgment application should not be struck out. So, as here, we were ad idem before the learned judge for opposite reasons.
It was a mere procedural accord the judge learned in his early days.
So that's how we see the waterfall of issues on the cross appeal. Can I turn then to our introductory observations before I get into issue 2? And there are 2 of them. First, and this is the point my Lord Justice Phillips put to me about 10 minutes ago, I absolutely recognize and accept that the instinct of the court is usually that a claim, especially a fraud claim, should be determined on its merits, so that if the alleged fraud did occur, the fraudster is held to account, and if it did not, then the claim fails. One readily understands why that is the court's instinct. But if there is an overarching theme that is common to many of my submissions on the cross appeal, it is that there are some situations in which that instinct should give way to something more important than the disposition of an individual case on its merits, such as the integrity of the administration of justice. It is fair to say, and I would accept, that the threshold for that is high. It is also fair to say, perhaps, that the threshold is rarely met in practice. But that is because it will not usually be the case that the claimant's misconduct is so serious that to allow the claim to continue would itself bring the administration of justice into disrepute.
Do you accept, though, that one thing which a sanction must be is proportionate?
Yeah.
And that means, proportionate means a balancing exercise, necessarily. On the one hand, you've got the abusive behaviour. And on the other hand, you've got depriving of the claim.
Yes.
And assessing the proportion between those two things. I mean, here, at the time the judge was dealing with it, he hadn't got a full understanding of the nature and effect of the abuse, not least because he hadn't had the information review hearing. And he didn't know the strength of the fraud claim because it was nowhere near trial.
Yeah.
Now, it seems to me that you might be cases where you could say, well, this is so appalling that we don't have to consider that. Prima facie, that is an important proportionality balance, isn't it?
Absolutely, my lord. I wouldn't disagree with any of that. Your lordship said towards the end of the question that you put to me that there may be some cases where it's so appalling that one can't allow the claim to continue. Now, my case on the cross appeal, I'm either right or wrong about this, is that this is such a case. But in principle, I accept, of course, that proportionality...
Well, it might depend on how appalling the fraud is as well, mightn't it?
And I'm going to deal with that, both on the law and the facts. I mean, I could do it now, but it seems to me it would be more logical to do it when I get to issue 1 because I need to lay the foundation for it. But, I mean, that's actually one of the biggest topics on the cross appeal. We have various reasons why we say either that's wrong in principle to have regard to it, or if it's right in principle to have regard to it, this is not the sort of case in which it carries any weight. Because we say no misrepresentation, no dishonesty, no reliance. Now, I'm not inviting the court to make findings about the underlying substance, and maybe the court isn't actually in a position to do it. But I just want to look at that topic as a standalone topic, probably tomorrow, if I may. But I very much have that in mind, and I appreciate it.
But for example, if what was established at the information review hearing is that the material which was produced demonstrated that the X had been involved in a conspiracy with his clients to cover up and perpetrate or cover up the very fraud that was being perpetrated, and what the pretence had revealed was that exercise, then that might have a big impact on one's assessment of the relative merits of striking out versus the fraud.
So it seems to me, my lord, the answer to that will turn on 2 things. The first is, in the example your lordship posits, would the iniquity exception be engaged? And second, if it would, what is the right balance between exposing wrongdoing and imposing a sanction for the abuse that has occurred in this case? And I'm going to deal with both of those points. I'm not trying to run away from the merits at all. It's simply that it strikes me that it's going to be easier to deal with it once I've done issue 2. But I'm very happy to do the other way around.
But one thing I have to bear in mind, sorry, I'm cutting across a lot of your arguments.
Not at all, not at all.
In a similar way to the approach of Mr. Justice Knowles, I think in the Mozambique case,
Yeah.
where he found that Mozambique had deliberately destroyed relevant documents to the prejudice of the other party. He nevertheless said, well, I'm not going to decide now that the claim should be struck out. I'm going to wait to trial to work out what is the appropriate sanction, stroke out, inference to draw, because that is the point at which it can be done appropriately. And what he did at trial, whether rightly or wrongly, was to determine that he could draw adverse inferences against Mozambique,
yeah.
which would deal with that issue. But he could only do that at trial, and
Yes.
in his view, only do justice at trial.
Yes.
Now, whether that was right or wrong, that is an approach that seems to me could be applicable here,
Yeah.
which is the time you can most fairly assess what is the appropriate proportional balance between egregious abusive conduct by the claimant and egregious fraud by the defendant alleged on either side, is when you actually know what all the facts are.
Yeah.
And then you can not only work out, have a full understanding of the respective misbehaviour, misconduct, but you can also form a proper view as to what is a proportionate sanction for
Yes.
the former.
Yeah, no, I understand, but it seems to me, my lord, that a premise in the solution that your lordship is putting to me is that the merits of the substantive claim against my client is legally relevant to the choice of sanction. And my submission is one needs to test that premise very carefully. It's not actually a point which has been the subject of any direct authority. Yeah.
I'm going to unload on you, not because I want you to have to deal with these points now,
Yes.
as they're points that are troubling me.
Of course.
I wanted you to have the chance to hear it now rather than tomorrow, and then you'll have a chance to discuss it with your team.
Yes.
But I'm just searching for what is a coherent answer to this issue when similar issues arise in other areas of law.
Yeah.
And just at the moment, at least, witnesses who perjure themselves, parties who perjure themselves and who forge documents. Not only do we not generally, if they have a good claim, deprive them of that claim, we're pretty circumspect about depriving them of all of their costs entitlement. And the case law on that, and there's a recent decision of this court called Ward, which came out about 2 weeks ago, but it picks up earlier decisions, makes the point that if you're to use the costs order solely as a sanctioning tool, rather than as a remedial process of addressing the consequences of the misconduct, then it has to be proportionate, and that involves looking at the behaviour of both parties, including whether there has been appalling behaviour on the other side. We have clean hands as a doctrine that can deprive you of equitable relief.
Yes.
But generally, and there's a very good article by Nick McBride about this, which I suspect Mr. Georgie has read, possibly you, makes the point generally you have a legal right to fall back on.
Yeah.
So it's not generally a forfeiture
No.
in the conventional sense. And then we have the insurance cases where we used to have a fraudulent devices doctrine,
Yeah.
which was subjected to successful attack on the basis there are other procedural mechanisms for dealing with dishonesty in support of a valid claim.
Yeah.
And I'm just trying to work out how this bit of the puzzle fits in and can achieve coherence with what might be a response to similar issues in other areas of law. So apologies for that.
No,
sort of
not at all. If I may say, I'm very
now, but just to give you a chance.
I'm very grateful, and I'm not going to pretend that this is straightforward. I mean, to my knowledge, the precise issue that is now before your lordships has not been the subject of any direct decision, certainly in this jurisdiction. There's some Canadian authority that we've identified. But a central submission I'm going to be making under issue 2 is that privilege is different. And that is what distinguishes it from some of the examples that your lordship has just put to me, which I certainly don't quarrel with. And indeed, I'm, in the hope it's helpful, I'm positively going to identify some further potential difficulties with my case and try to deal with them. For instance, is there coherence between the approach to remedy in the civil law and the approach to remedy in criminal law in relation to abuse? Because I would immediately accept that one of the factors the courts have consistently said should be taken into account in the criminal law is the gravity of the offence. So it might be said, and no doubt my learned friend will say in response, that if you can take the gravity of a crime into account, why can't you take the gravity of alleged civil wrongdoing into account in working out what's the proportionate sanction? I'm going to have to deal with all of that. But what in my respectful submission makes all the difference, maybe not all the difference, but a significant difference, and this is also why, my lord, it may be different to Mozambique or cases like it, is that here we are dealing with legal professional privilege. which is not what Ms. Justice Robin Knowles was dealing with. It's not what went wrong in Arrow nominees. We are dealing with something that is central to the rule of law and indeed to the fairness and the functioning of our legal system. Now, it may be that that is not enough to get me home, but that's what we say distinguishes privilege from other things. And that's why the key issue of principle that arises on the cross appeal, it's not so much about this case. It's what is the...
Forgive me, though, but I thought you were arguing this appeal on the basis you accept, for these purposes, the documents are not privileged.
I do, but that's not inconsistent with my submitting that an attempt to get access to privileged material is such a serious abuse because of the threat it poses to legal professional privilege that the only appropriate sanction is to strike the claim out, particularly where this is not a case of a failed attempt to get access to documents. It's a case in which you deliberately try to get privileged documents. You get extensive information, whether privileged or not, only by reason of that abusive attempt. And that, we submit, is what distinguishes privilege hunting, which I'm not using tendentiously, I hope, it's just convenient shorthand, instead of having to say every time deliberate attempt to get access to privileged documents. That's what distinguishes this form of abuse from other forms of abuse. And that's actually why I wanted to start with issue 2, because that's my key point under issue 2. But what I was submitting, my lord, not at all, genuinely, it's very helpful, and it's much better this way. What I was submitting was that the threshold for this form of abuse, where the claim itself, where allowing the claim to proceed would itself bring the administration of justice into disrepute, the threshold for that is high. But where that high threshold is met, as we respectfully submit it is in this case, it is no answer to say, as the claimants do, that they allege serious wrongdoing by my clients. The reason why that is not an answer is that the court does not act for the defendant's benefit, but for a value or principle that is more important than these parties in this case, namely maintaining public confidence in the administration of justice. One sees this point, that the administration of justice matters more than the individual case, in the authorities about abuse of process in the criminal law, and I'll go to some of those. But what those cases say is that even for offences as serious as murder, and even where a fair trial is possible, the court will stop the prosecution as an abuse of process if allowing it to continue would bring the criminal justice system into disrepute. I mean, a well-known example, we haven't got it in the bundles, but it's a case called Bennett in the early 1990s, where on the assumed facts in the House of Lords, which others have subsequently suggested was in fact a false assumption, Scotland Yard colluded with the South African police to kidnap Mr. Bennett, who was at the time in South Africa. He was put on a plane to New Zealand, purportedly because he was to be deported to New Zealand. But the flight stopped at Heathrow, where he was arrested, and he was then charged with offences, which he was said to have committed here. And the issue was, is that an abuse of process? Now, it was common ground in that case that Mr. Bennett would receive a fair trial, because the circumstances of his abduction had nothing to do with the underlying facts. There was no contamination of evidence, there was no issue about privilege. But what the House of Lords said was, if allowing the prosecution to continue would bring the administration of justice into disrepute, it must be stopped.
It's a very different scenario where you're dealing with prosecutions by public prosecuting authorities, as opposed to in this litigation between private individuals, where what you're effectively saying is that the misconduct of one of those parties should be taken to trump, as it were, strong mandate that we do justice in individual cases and don't drive people from the judgment seat without good cause.
Yeah.
And that's where we very much do have the principle of proportionality, which doesn't apply when you're looking at prosecution, where the primary importance is that prosecuting authorities behave properly.
Yes. No, there's certainly a distinction between crime and civil cases, and we may need to explore in which direction that distinction points. But to give your lordship an example of a civil case, which may be the closest equivalent to the Bennett example, is Raja and Van Hook Stratton. I mean, we'll look at it again. My learned friend took the court to it in the course of submissions this morning. But that's a case in which you have a claim in the Chancery Division, a money claim, against Mr. Van Hook Stratton. Mr. Van Hook Stratton arranges for Mr. Raja to be murdered, importantly, for the purpose of coercing his estate to settle the claim on favourable terms. I can't remember if the court was taken to that this morning. You may have been, but there's a finding by Mr. Justice Lightman at the preliminary issue trial that not only did Mr. Van Hook Stratton arrange for Mr. Raja to be murdered, he did it because he thought that the estate would settle the claim on favourable terms if Mr. Raja were to be murdered. And what Mr. Justice Lightman says, certainly as we read the passage, paragraph 32, is that if you murder your opponent for the purpose of gaining a litigation advantage, there is only one sanction that is appropriate, and that is to strike your claim out. Now, that is a civil case. I appreciate murder is different from what we're concerned with. I mean, what Mr. Hausman case, he asked me when I drew this case to his attention, he said it was big news when he was a pupil. And then he then said to me, but can you equate what happened in this case with what happened in Raja? In one sense, obviously I can't, because murder is not the same as privilege hunting. But that, with respect, is the wrong question. The right question is this a case in which allowing this claim to continue would bring the civil justice system into disrepute? If I'm wrong about that, I'll probably fail on the cross appeal. But if I'm right about it, then there's only one appropriate sanction.
But forgive me, but isn't bringing the civil justice system into disrepute the category, effectively the category of abuse? And then you've got to look at what is the sanction.
So I'm not sure with respect I'd accept that, my lord. It goes back to a point I think my Lord Justice Foxton put to my learned friend. It may lie in terminology. Sometimes there is conduct which is contrary, which is an affront to justice, and that constitutes an abuse. And you then have to ask, what's the appropriate sanction for it? But there are rare cases where not just the conduct, but the court permitting the claim to continue would bring the administration of justice into disrepute.
But that is simply saying that the sanction for that abuse is to strike out.
Yes, but the reason the sanction for that abuse is to strike out is that anything else would bring the administration of justice into disrepute. We can, and that's we would submit the true explanation of.
But again, that's what that's really saying, is that this is effectively necessarily a situation where the proportionality of the sanction, the proportionality test, must result in a strikeout.
Yes, but as a conceptual point, I wouldn't disagree with that. But my submission is there is a subset of cases where the only proportionate sanction is to strike the claim out. And the question we are debating is this within that subset of cases or not? And that's what I wanted to develop under issue 2, if I may. And
Well, you say that murdering your opponent is such a case.
Yeah.
But you also say that, any form of privilege hunting? Looking at your opponent's notebook in court?
No, I don't.
That automatically means strikeout?
No, I don't say that.
So what's the definition of what takes it into, what do you have to do to mean automatic strikeout?
So two answers to that. First, if I've succeeded on issue 1, so if your lordships take the view that the judge's exercise of the discretion was flawed, then I don't have to persuade you that strikeout is the only conceivable sanction. It is sufficient for me to persuade you that strikeout is the appropriate sanction in this case and more appropriate than any other sanction.
No, but you're saying this is a case where it must be.
Yes, I do say that, but that's because this is not a case where you have a failed attempt which is the notebook example, where you look at a notebook and there's nothing in it. Or, for instance, you try to hack your opposing.
No, what if you glance at the notebook? There is something written there.
Well, it would depend on the circumstances. But if, for instance, you deliberately go looking at a notebook which has the sort of stuff the claimants got from X, then it may well be that the only appropriate sanction is strikeout. I mean, I'm not saying it's not fact sensitive, but I am saying that
there's no proportionality test.
There is a proportionality test, but the application of that test in some cases will result in only one possible sanction. That's how I put it. But
I'm getting confused now.
Can I try again, my lord? Can I put it this way? Let's assume for a moment that the court were to find that the learned judge's exercise of his discretion was flawed in one respect or another, possibly because you say that he should
win on issue 1.
That's issue 1. So let's assume that I win on issue 1, and we're into how should the discretion be re-exercised, almost as if it were being exercised for the first time. I say that there are 7 reasons why the appropriate re-exercise of the discretion in this case is to strike the claim out. And can I just identify what the 7 reasons are, and then I'll develop them in turn. The first point concerns the seriousness of the abuse. The second point concerns the nature of the abuse and why it's different from other kinds of abuse. The third point concerns the need for deterrence. The fourth point concerns the few authorities on the sanction for this particular form of abuse, privilege hunting. The fifth point concerns the claimant's response to and use of the black cube evidence, in particular the improper decision to review it. The sixth point concerns the prejudice already caused to the defendants by the abuse. And the seventh point concerns some findings made by the learned judge about the claimant's conduct more generally. I ought, in fairness, to acknowledge that that seventh point is a new point. It's not in my skeleton. Frankly, it's not going to get me home on its own, but I'll explain what it is when I get there. Can I briefly take those points in turn, and then I'm going to deal with things like what is the relevance of the fraud claim against my clients, how strong is it, how is it to be weighed against these factors. But that, as it was, my positive case about why the appropriate re-exercise of the discretion in this case, if it holds to be re-exercised, is to strike the claim.
I just say, forgive me, maybe I'm misunderstanding what you said, but we've now got 7 factors which you're going to look at as to how you re-exercise this discretion. Yeah. But I thought what you were just putting to us a moment ago was that there are some abuses, of which this is one, which are so serious and of a particular nature that the only appropriate thing you can do is to strike out.
Yeah.
Now that doesn't seem to me to be a matter of weighing 7 factors. That seems to be effectively an absolute rule of law.
No, indeed. But the second of my 7 points goes to that point. When I said nature of the abuse, what I'm going to be submitting under that heading is that...
But if you're right on 2, then why do we need 1, 3, 4, 5, and 6?
I don't, but I've got various reasons, and it may be that I don't need all of them. It's just my positive.
There's always the chance that some of them may prove more attractive.
Indeed, or perhaps none of them will prove attractive. But those are my 7 points. I mean, I don't necessarily...
So some of these are factors which have weight. Others are things which drive one to a definitive result in any event.
I think that's right, my lord. Perhaps the way to put it is this. Of the 7 points I identified, 5, 6, and 7 are specific to the facts of this case, but 1, 2, 3, and 4 are probably relevant in any case involving privilege hunting. Because 1 is about seriousness of this form of abuse, 2 is about the nature of the abuse, 3 is about deterrence, 4 is about the authorities. It's not really a separate point. But sort of feeds in. Can I turn then to the first of those 7 topics, which is seriousness? There are a number of reasons why we submit that privilege hunting is a particularly serious or egregious form. For one thing, privilege hunting by its nature involves corrupt or dishonest conduct. And that is so irrespective of the means by which the privilege hunting occurs in any individual case. The authority for that proposition, that privilege hunting by its nature involves corrupt or dishonest conduct, is the judgment of this court in the Nigeria case. Now, there are various points to which the Nigeria case is relevant, but on this point, what happened was, at first instance, Mr. Justice Robin Nowes found that there were 3 irregularities which brought the case within Section 68(2)(g, I think it was, of the Arbitration Act. And that requires a serious irregularity which has caused or will cause substantial injustice. The third of the 3 irregularities was the decision made by PNID, the claimant, to retain and use Nigeria's internal legal documents. Can I just show the court that? I'm not sure I've taken the court to it. Nigeria is volume 3, tab 42. Page 1159. At paragraph 217, the learned judge said, it's in the right-hand column, paragraph 217, page 1159. When I refer in this judgment to PNID retaining Nigeria's internal legal documents, I mean its choice, rather than returning the documents immediately and unread, to read them and to take the benefit of the information they conveyed. PNID's improper retention of Nigeria's internal legal documents, received at various points during the arbitration, enabled PNID to track Nigeria's internal consideration of merits, strategy, and settlement during the arbitration. I should also draw the court's attention to para 215, because it's picked up when the case comes to this court. On the same page, Mr. Andrew and Mr. Burke, Casey, knew that PNID and they were not entitled to see these documents. Their decision not to put a stop to it, at least by informing Nigeria or immediately returning the documents they knew were received, was indefensible. If we then go to para 493, please, it's page 1197. At 493, the learned judge says, there remain 3 things that bring the case within 68(2)(g as an irregularity. Each amounted to fraud by which the awards were obtained, and by reason of them, the awards or the way in which the awards were procured was contrary to public policy. And if we drop down to 496 on the same page, we see that the third of those things was PNID's improper retention of Nigeria's internal legal documents that it had received during the arbitration. It retained those rather than return them unread. Now, my learned friend, I think, submitted just before the short adjournment the reference to fraud at para 493 is not a reference to PNID's conduct alone, but to the fact that they obtained an arbitral award by fraud. But that, with respect, isn't right, and we see that in the Court of Appeal judgment. Because what the learned judge and this court both held was that deliberately retaining and using the internal legal documents of an opposing party, whether or not all of them are privileged, constitutes corrupt or dishonest conduct. And just to make that good, sorry to jump back and forth, but if we go back for a moment, please, to page 1159, which we looked at earlier. At 217, which I showed the court, the phrase internal legal documents is a defined term, hence the capitalization. And you get the definition at 210 on the same page, left-hand column, where the judge says, I have reviewed these internal documents and at least some were plainly subject to legal professional privilege. And then 211 says, I shall refer to these internal documents in the balance of the judgment as Nigeria's internal legal documents. So just pausing there, because this goes to a point my Lord Justice Phillips put to me. What was found to be fraudulent was PNID's decision deliberately to retain and use internal legal documents, not all of which were privileged. That's the point Mr. Hausman Casey made in his judgment below, and we respectfully agree with it. If we then pick up the Court of Appeal judgment, please, that's in the next volume, volume 4. I should say, the court will know this. This wasn't actually an appeal by PNID. Its application for leave was refused. But Mr. Andrew, the solicitor, about whom critical findings were made, he sought permission to appeal as a third party. And that's what this judgment is dealing with. If we could go to page it's tab 47, I should have said. Tab 47. Volume 4, tab 47. And page 1441. Para 163. So far as concerns the other two possible interpretations of 592, that's a reference to the judgment below. In my judgment, the better reading is that prepared to use corruption is not intended to refer to Mr. Andrew at all, but only to those involved in a corrupt scheme of bribery. However, even if that were wrong, and prepared to use corruption is a reference to Mr. Andrew as well, the judge is clearly identifying Mr. Andrew with corruption in the sense of his involvement in the improper obtaining and retention of FRN legal documents. In this context, it is striking that, as set out at paragraph 45 above, counsel was constrained to accept, in answer to Lord Justice Jeremy Baker, that deliberately keeping the FRN legal documents and retaining them, as found in 214 and 216, could be described as corruption. That is obviously correct. What the judge describes in those paragraphs was clearly corrupt behavior. Counsel also accepted in answer to me that if the judge had said at 592 that Mr. Andrew was driven by greed and prepared to act dishonestly, there would be no...
Are we debating legal concepts here, or simply going to this judgment for the purposes of determining what adjective to apply to particular conduct?
I'm going to it only in support of the submission that this form of conduct is inherently dishonest or corrupt.
As those terms are used as a matter of everyday English, presumably, rather than a particular legal meaning they may have in a statute or rule. I'm just wondering whether this really is a question of authority or just a question of...
No, it's the latter, my lord. I think what I'm submitting is in the minds of right-thinking people, which is the touchstone for abuse, as Lord Diplock articulates it in Hunter.
You've gone to the Court of Appeal to establish what the minds right mean.
It seems to be in dispute based on what my learned friend submitted earlier today, but we respectfully agree. One does need authority, perhaps, to make the submission that if you deliberately keep your opponent's internal legal documents, whether they're all privileged or not, that would be regarded by right-thinking people as a dishonest thing to do. That doesn't get me home on its own. It's just one point I make in support of characterizing this form of conduct as a particularly serious form of abuse. Now, not only is privilege hunting inherently dishonest or corrupt, it will usually also involve the use of dishonest or criminal means. Because if you want to get your hands on your opponent's privileged information, in practice, you can only do that, usually, by lying to the opposing party or their solicitor, or offering a bribe or something of that sort.
Are we still on your first point, or have we moved to your second?
First point, on seriousness. I'm just identifying various things that make this form of conduct serious. And finally, on the seriousness point, my first point, whether it actually does so or not in an individual case, this is a form of abuse that is capable of jeopardizing the fairness of a trial. In every case, capable. Of course, if the fairness of the trial is actually jeopardized, that's a problem in itself and may be an independent ground for some form of response or sanction. But even where the fairness of the trial is ultimately unaffected, for example, because the attempt to obtain privileged documents failed, it drew a blank, or something was obtained but there was nothing in it, even in such cases, it may have a chilling effect on the willingness of the person who finds out about the attempt to continue to confide in their solicitor, a point my Lord Justice Mayers put to my learned friend in the context of hacking. So that's what we say about our first of our 7 points, that this is a serious form of abuse.
In a way, isn't destroying highly relevant documents which would have revealed your bad behaviour just the obverse of this? Isn't it just as serious?
Or forging.
Or forging documents, indeed.
That's for your case. Perjuring yourself.
Yes, I mean, yes, it is. But what's different about privilege, and I mean, that really takes me to my second point, is that whereas those things are serious in the sense that they can have a similar corrupting effect on the forensic process, they do not threaten an element of the rule of law in the way that this form of conduct does.
Why not going into the witness box, taking an oath, and then deliberately lying? Why isn't that about as serious as it gets?
So I'm not suggesting it's not serious. I'm not suggesting that it's not as serious as this. But all I'm submitting under my first point is that this is serious. That's not enough on its own, but it is serious. And we then have to ask, what is it that distinguishes this, if anything, from the other forms of conduct that your lordships are putting?
And I'm using the word in a different sense. What you say distinguishes is privileging the legal relationship above other wholly inappropriate, dishonest and corrupt behaviour that may occur in the context of litigation. It's quite a lawyer-centric view.
I would accept that. It is a lawyer-centric view, but it's not, as it were, about protecting lawyers. It's about protecting the way our forensic process works. And that's actually a convenient segue into my second point, which is this point. What is it that distinguishes this form of conduct from other forms of abuse? And I can at least, I think, make a start on this point today. Now, I have to accept at the outset that there is very little authority on the submission that I'm about to make concerning the nature of different kinds of abuses, and to some extent one may have to approach it from first principles. If one looks at the reported cases about abuse, one immediately identifies lots of different forms of abuse. Say Henderson and Henderson, re-litigation abuse. You have Grovit abuse, as it has come to be known, which is where you unilaterally put a claim on hold without asking the court because it suits you to do it. Deliberately advancing a false claim, as in the Summers case and in other insurance cases. Murdering an opponent for gaining a litigation advantage, as in Van Hoogstraten. And it may be that these different forms of abuse protect different interests. But there is, we would submit, a broad distinction between an abuse that occurs within the court process, for example, by taking a step in the litigation, and an abuse that occurs outside the court process. This is actually a distinction that the learned judge below identified in an email to the parties in advance of the hearing and sought submissions on it. And he described the second category as non-white book abuse. In other words, things that you do outside the litigation, which for one reason or another constitute an abusive process. It is fair to say, as the learned judge himself observed in argument, that this is not a watertight distinction, because it's not always easy to distinguish between things you do within the court process and things you do outside it, but with the requisite nexus to the court process. And in drawing the distinction, I don't mean to suggest, as I've already submitted, that white book abuse, as it were, is not serious. It may be, and it often is. The example your lordships put to me are examples of that. Deliberately advancing a fraudulent claim, perjuring yourself in the witness box. Those are very serious forms of abuse, but they're white book abuse. And as we know from cases like Summers and Arrow nominees, even in the context of white book abuse, there are some circumstances in which the court will strike out the claim, even though a fair trial in the narrow sense remains possible. Now, so far as non-white book conduct is concerned, that is to say, things that you do outside court, not every form of such conduct which is disreputable or warrants criticism will amount to an abuse. For instance, as I think Toby Landau PC pointed out in a lecture recently, it has become more common in modern litigation to write aggressive letters to the other side with lots of adjectives, and the courts have often deprecated that, but are unlikely to characterize that as an abuse. And I make that point only to support the submission that there is in practice a very high bar for making a finding of abusive process by non-white book conduct. And we say that in cases where that high bar is met, that will usually be because the conduct in question is an attack on the administration of justice, in the sense that it is a deliberate attempt to undermine some fundamental norm or value of litigation in this jurisdiction, such as murdering the opposing party, attempting to bribe the judge, things of that nature.
I'm just trying to identify the distinction between white book and non-white book conduct at the moment, because if it's to support, as it appears to be a step in the next argument, I want to just make sure I understand what it is. I mean, obviously, the fact you do not need to produce privileged documents is a white book recognised concept.
Yes.
Witness statements are provided for in the white book. Equally, if I offer a bribe to my opponent's witness to give perjured evidence, is that white book conduct or non-white book conduct?
I see exactly what your lordship means. Indeed, that's why I think in the end the learned judge observed an argument, having raised the point. He said it may actually be a flawed distinction because you can't draw it. Yeah. I'm not drawing it for analytical purposes. I think I'm just making a forensic point that if you do something outside court and the court has found that that amounts to an abusive process, that in practice will usually be because the conduct in question is a deliberate attempt to undermine something very fundamental about our system of litigation. Because if it's something short of that, like writing letters or whatever, then even though the court might criticize it, it's not going to characterize it as an abuse. The two clearest examples of this may be Van Hoogstraten and the Catalyst case. I mean, what happened in the Catalyst case, which the learned judge refers to in his judgment, is there was very hard-fought commercial litigation in Toronto, I think, between the Catalyst Group and the Westface Group, who are two leading lights in the private equity business. Catalyst suffered a somewhat chastening defeat at trial before Justice Frank Newbold, who was the trial judge. They then hired Black Cube, the same investigation agency we are concerned with in this case, to conduct a sting operation on Justice Newbold.
Well, he was by then retired Justice Newbold, who was applying for hire on the crowded arbitration market.
Indeed.
And they were potentially going to appoint him as an arbitrator.
Precisely.
So the sting operation was very similar to what we see in this case, with a potential new client for a solicitor.
Precisely so. That's what gave Black Cube their opportunity. And what they did, of course, was the retainer letter in that case was in the end disclosed, because what happened was Catalyst and Black Cube asserted privilege in communications between Catalyst and Black Cube. I said litigation privilege. Somewhat ironically, that failed because the iniquity exception was engaged. So they were ordered to disclose all of this. And it emerged that Black Cube had been promised a bonus of $75,000 or something per hit. So if they were to elicit anti-Jewish comments from the judge, 75,000. If you elicit a comment which shows the judge is biased, another 75,000, with remuneration set to increase to 11 odd million. But the important point about the case for our purposes is, this is probably, to the extent the distinction has any utility, non-white book conduct, in that Black, you go and talk to a retired judge who was the trial judge for the purpose of bolstering Catalyst's case on appeal. Now, the Canadian court characterized that conduct as an abuse of process, which is the reason why privilege was lost. But the submission I'm making, which is only a forensic point, is that it has to rise to this sort of level for the finding of abuse to be made. If it arises out of something that happens beyond the court process, bribing a judge, murdering your opponent, it's that sort of thing which is a deliberate attempt to undermine some very fundamental value in our litigation system that gives rise to the finding of abuse. Now, because it's only a forensic point, it doesn't get me home, but what we say is that in cases of this kind, which of course don't come along often, sometimes allowing the claim to continue would itself bring the administration of justice.
The fundamental value at stake in the Catalyst case.
I'm sorry.
What was the fundamental value that was undermined in the Catalyst case?
That judges should not be deterred from doing their job.
That the retired judges should not.
Yeah.
I mean, I'm just not sure it works.
But presumably only because the judge was retired by that point.
Well, I'm just trying to work out what it was. Clearly, bribing a judge would go to the very heart of it.
He had in fact done his job because he produced his judgment and gone off to enjoy his retirement, or not enjoy it because he was going to do other things.
Yes. It may be that it simply brings the... Well, can I put it this way? Catalysts do this and then they pursue their appeal. And let's say they succeed on the appeal, even though they got nothing of value from Justice Newbold. The fact that a litigant who attempted to bribe the trial judge in an attempt to improve their prospects on appeal was then allowed to pursue the appeal and won the appeal, itself brings the administration of justice into disrepute. I mean, I can't identify specific value that corresponds to privilege, which is undermined there. But
was the appeal struck out? It wasn't, was it?
The appeal, I don't think any abuse point was taken.
I don't think anybody asked the Court of Appeal to strike it out, but I don't think they did.
There was no strikeout application, no.
So although they said some damning things about the conduct, in the end it was just a slap on the wrist.
Well, it's true, but that might have been a consequence of the fact that nobody took the point in the form of a strikeout application. But if you take the Van Hook-Stratton case, which is probably the closest domestic equivalent that we have to Catalyst, what's the I mean, one might ask the same question of Van Hook-Stratton. What is the fundamental value? But I would suggest that in the minds of right-thinking people, the idea that a litigant, despite murdering their opponent for the purpose of gaining a litigation advantage, can nonetheless pursue that claim to judgment in the ordinary way.
If Mr. Van Hoogstraten had been convicted and given a lengthy sentence for the murder, I think he was acquitted.
He was acquitted.
The judge found that he had in fact committed it. The argument would have been available that the state had imposed the sanction for the crime, and wasn't the function of the civil court to, as it were, impose its own sanction. I mean, it's not a question that arose.
No, I see that. But the answer to that would probably have been that when Mr. Justice Lightman strikes out, not just the defense, incidentally, also a counterclaim. So he struck out the counterclaim. He's not doing it to penalize Mr. Van Hook-Stratton. He's doing it because if he does anything short of it, it's going to bring the civil justice system.
So they're not actually sanctions then in that sense. They are the court protecting justice from being brought into disrepute.
Precisely so. And that we would suggest is a point in our favour, because that's exactly the same test you get in the criminal law. Contrary to what my learned friends submitted, I mean, others know a lot more criminal law than I do, but I gather that in the at the criminal bar, the convention is to refer to this form of abuse as limb 2 abuse, because if you go back to Latif and Bennett and cases from which this derives, they identify two entirely distinct and separate grounds on which you can stop a prosecution. One is you can't have a fair trial. So that's fair trial in the narrow sense. It's unfair to the accused. And the second is, although you can have a fair trial, it would bring the criminal justice system into disrepute. Indeed, my learned friend took your lordships to Warren, but Warren actually says exactly this, what I've just submitted, and perhaps I can quickly show the court that. Warren, it is in volume 2, and I think this point is at para 35. It's volume 2, tab 22, page 508.
Sorry, 50 what did you say?
Volume 2, tab 22, page 508.
Thank you.
So the board at para 34 records a criticism by the Court of Appeal in that case, of the Grant case. And the criticism was the jurisdiction to stay proceedings as an abusive process extends to circumstances in which there's been no unfairness to the accused. Then they say the board does not accept this criticism of R and Grant. The second category of case where the court has the power to stay proceedings as an abusive process is, as already stated, one where the court's sense of justice and propriety is offended if it is asked to try the accused in the particular circumstances of the case. It is unhelpful and confusing to say that this category is founded on the imperative of avoiding unfairness to the accused. It is unhelpful because it focuses attention on what is fair to the accused, rather than on whether the court's sense of justice and propriety is offended, or public confidence in the criminal justice system would be undermined by the trial. So that's the principle. There are two distinct limbs, hence the nomenclature of limb 1 and limb 2. And in our respectful submission, your lordships exercising civil jurisdiction have exactly the same power. There is limb 1 and limb 2 in the civil law as there is in the criminal law. And I've already accepted that it's a rare case and it takes very serious misconduct to engage limb 2. But if this is such a case, there's only one sanction.
Right.
Yes.
It's going to depend upon whether there is another sanction, the imposition of which will mean that the confidence of right-minding people in the justice system or the perception of it is not brought into disrepute.
No, I would accept that, absolutely. And in a way that goes back, I think, to a question my Lord Justice Males asked my learned friend, which is, what do you say is the sanction that should be imposed in this case if there is an abuse? And presumably what's on the menu is indemnity costs, but that's not really a sanction in litigation of this kind. I mean, it may be a jury point, but that tends to be demonstrated by the fact it's always been the claimant's preferred sanction. They actively encourage the learned judge to resort to its cost jurisdiction. What else is one left with? One has
freezer.
The discharge of the freezer. Yes, I see. I mean, they, for their part, consistently resisted that.
Oh, I'm sure.
But there's some force in, if I may respectfully say so, in that. We've put an authority, if I may just very quickly finish off on this point, my lord. Mm-hmm. We've put an authority in the supplemental bundle, the decision of Mr. Jeffrey Voss, QC, as he then was, in a case called Merrin Meat. I'll come to it tomorrow, but what happened in Merrin Meat was a pretty extreme case, because the claimant got interim freezing and search orders against the defendant. The defendant, at the return date hearing, admitted fraud. So you have a case where there's an admission of fraud, but Mr. Voss QC discharged the freezing orders on the ground that the claimants had deliberately lied to the court. Sorry, that's a tautology. The claimants had lied to the court when they obtained the freezing order. He was pressed with the submission that my learned friend makes, which is, if you discharge a freezing order against somebody who's admitted fraud, that is as good as striking out the claim, because they'll make themselves judgment-proof. Mr. Voss QC's answer to that was, that's nothing to the point. Sorry, that's overstating it. That's outweighed by the need to demonstrate, both to the claimants and other litigants, the importance of complying with the duty of full and frank disclosure and fair presentation. The question then would become, is that sufficient sanction, or should the court go further and strike the claimant? And perhaps I can come back to that tomorrow.
Yes. How are you doing in terms of time? When do you expect to complete your submissions?
May I reflect on that overnight, my lord? In the light of the exchanges we've had, it may be that I can be shorter on some points than I had envisaged. I'll go as quickly as I can. I'd always intended to use the bulk of my time for the cross appeal,
Yes, of course.
recognizing the burden's really on me there.
All right, we'll resume at 10:30.
So roughly how long are you going to be? Have you any feel at all?
Sorry?
Have you got any feel at all how long?